Good morning, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's program, which is part of our Sophisticated Employer webinar series, sponsored by the firm's Labor and Employment Law Practice Group. Today's session is really going to be a good one, so we're glad you're joining us today. As you know, employers and HR professionals make decisions fraught with potential legal pitfalls, and that's why I'm glad we have with us today two of Plunkett Cooney's most experienced employment law attorneys who will help us traverse these topics and emphasize key decision points that require in-depth analysis in order to get them right. My pleasure to introduce these experts, both of whom are battle-tested attorneys on the front lines of employment law, as we like to say. Laura Dinan from our Petoskey office and Claudia Orr from our office in downtown Detroit. Welcome, Laura and Claudia. Before we get started, I would like to take a few moments to provide you with some background about our presenters and about our law firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 150 attorneys these days. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our employment law practice group includes more than 20 attorneys who work in traditional labor law, human resources consulting, employment litigation, and even some workers' compensation claims. Our Sophisticated Employer webinar series is designed to help HR professionals, risk managers, and business executives stay up to date on important legal issues, to provide you with HR best practices, and to discuss trends in workforce management. Our webinar has been approved today for 1.25 general recertification credit hours through the HR Certification Institute and 1.25 professional development credit hours through SHRM. Following today's program, we're going to send a certificate of completion by email, but that'll come probably to you early next week, so please be patient with us on that due to the holiday. I'll talk a little bit more about that later in the program. If you don't need CE credit for today's program, you can simply just disregard those certificates. And now just a bit of background about today's presenters. Laura Dinan has over 30 years of experience advising employers. She's built a successful practice representing public and private sector employers of all sizes throughout northern Michigan. Her expertise includes traditional labor and all types of employment law matters, and she's a past president and currently the Secretary of the Board of Directors of the Northern Michigan Society of HR Directors. Claudia has nearly 30 years of experience representing employers ranging from Fortune 500 companies to small businesses and nonprofits. She provides advice on all aspects of employment law and defends her clients when litigation and administrative issues arise. She also regularly serves as an arbitrator and a mediator in employment law cases. And Claudia is serving as a member of the Board of Directors of Detroit SHRM for the second time. And this time she's serving in the role of secretary. She also remains a member of the organization's Legal Affairs Committee. Now, just a couple housekeeping notes, and I promise we'll get started. As always, for the Q&A portion of our webinar, we're going to use the questions tool on your GoToWebinar navigation display, your dashboard. Please take a moment now to locate that window, the Q&A window, and feel free to enter any questions as they occur to you during the program. At the end of the presentation, we're going to try to answer as many as time permits. And the only caveat I'd like to add is to try to keep your questions a bit general in nature. We certainly don't want to get into too much specific information about your particular workplace and divulge any identities and those sorts of things. Finally, I want to mention today's session is being recorded, and that recording will be available on the event page of Plunkett Cooney's website, which is located at plunkettcooney.com. Feel free to share a link or direct any colleagues who couldn't attend today to that page, and they'll be able to get the recording and the handouts. Thanks again for attending today's webinar. Now we're going to get started. And Laura, I believe you are leading off the discussion today, so please take it away.
Thanks, John. Thanks, everybody, and welcome. Claudia and I thought that we would give everyone, including ourselves, a break from COVID issues. So I hope that this is a nice change of pace. And I think you can tell from the format, but basically we've picked a number of topics where it's kind of an either-or situation for employers, and we want to explain what the situation is and the different ways, the different choices that can be made and the consequences for those choices. So I'm going to start off with independent contractor versus employee. How do you classify them? An employee is defined by the Fair Labor Standards Act as any person who is employed by an employer. An employer is defined as any person acting directly or indirectly in the interest of an employer in relation to an employee, and employ means to suffer or permit to work. So an employee is hired by a company usually for an indefinite period of time, but we'll talk about that in the at-will versus just cause section a little later. Employees may receive benefits if a company offers it. An employer pays all payroll taxes such as unemployment, Social Security, income, workers' comp, unemployment, carries insurance including unemployment and regular liability insurance that protects their employees. The employer withholds the employee portion of any required taxes from the employee portion of pay for its employers, and the employer has to confirm through the I-9 that the employee is legally allowed to work in the U.S. So those are the types of things that make an individual an employee versus an independent contractor. Independent contractors, on the other hand, are not employees. They generally contract with a company or a person to do a specific job. It's usually for either a specific time frame that they're going to perform the job, or it's project-based. In other words, you hire them to come in and do a specific project and then they're done. Independent contractors have the ability to hire their own employees, subcontractors, send other people into work, and those individuals would work for the independent contractor, not the place of employment. The situation that comes to mind immediately on that topic is, say, if you hire someone to come in and paint, you might have some kind of medical office. Painting the walls is not part of your regular jobs. You would hire a company or an individual as an independent contractor to come in and paint the walls when business is not open. They could bring in workers. All of those would be independent contractors, not employees of the business. That's kind of simplistic, but that's the idea of who would be a legitimate independent contractor. If you hire independent contractors to do work, they're paid via a 1099, and they are responsible for paying their own taxes. The employer doesn't pay any sort of taxes or take take the employee portion of taxes out of any payments to them. They just pay them the complete agreed upon amount via 1099, and the independent contractor is responsible for paying their taxes. And it's a very suspect category. All the federal and state government view independent contractor relationships very suspiciously. The reason for that is because they're revenue generators. You just heard me say that if you bring someone on as an independent contractor, the employer doesn't pay any employment taxes on that individual. Whereas if they bring them on as an employee, they pay the FICA, they pay unemployment, they pay income taxes, and then the employee also pays all those taxes. So probably, I'd say about 10 years ago, Michigan and the feds aggressively began seeking out and auditing independent contractor relationships. And that is ongoing right now. We still have clients every day who are challenged on independent contractor classifications. So you have to be very mindful if you want to bring someone in as an independent contractor that it will be viewed suspiciously, and there are No, there aren't any consistent tests. Every agency uses a different test, it seems like, to determine if people are independent contractors. You can call a person's relationship with your company anything you want, but the government is not bound by that, and they won't just look at your designation and say, oh, well, okay, you must have properly determined it. Instead, they put these tests and they look at what the person does. And again, they all have different tests. So it gets very complicated. Basically, Michigan administrative hearing system, things like the Work Comp Bureau, unemployment, go by the IRS 20-factor test currently. It has flip-flopped over the years, but the IRS has this 20-factor test that they use, and Michigan's administrative hearing system is currently using that test. And on the other hand, Department of Labor, when enforcing the Fair Labor Standards Act, uses the economic reality test. And another test, which Michigan circuit courts use if a case gets in litigation there, they use a 3-factor test to determine if an employee is an independent contractor or an employee. So just listening to that should tell you this is a minefield. So be very careful if you are considering classifying someone doing work for your business as an independent contractor. You're probably going to be successful with that classification if the person has their own business, has a tax ID number, only works for your business for a few days a week, a few hours a week, or just a few weeks, doing one project like my painting example. And especially if the individual or company works for a number of different people. In other words, they might have their own. I have a lot of situations where a person has their own business, has their tax ID number, but they devote 40 hours a week to a particular business, not on a project basis, but on an ongoing basis. And even though they have their own company, one of the main requirements is that they hold themselves out to other businesses to be available to work for them. And if you're working 40 or 50 hours for one business, it's highly unlikely that you have time to hold yourself out to other businesses. So that would be a situation where you would probably lose if you went against any of these agencies claiming someone was an independent contractor. So what should your default position be? The safest route is to call someone an employee if, in fact, they are really working for your company. If someone files a complaint with the Department of Labor or one of the agencies, or if they audit you for any reason, the government agencies are always going to take the position that the person is an employee unless you can prove otherwise. And again, as I mentioned earlier, it's a real big area for the reason that if they find people have been misclassified, it's a revenue generator. So if they come in, find you misclassified them, there are consequences. If you've treated somebody as an independent contractor and they're found to be an employee, you could be liable for not offering or covering them under your benefit plans, your insurance policies, for back taxes, both yours and theirs. So under the Fair Labor Standards Act, an employer would be liable for back overtime, if any, and back wages if the time wasn't properly tracked, i.e. you just had an independent contractor agreement with someone, they came and went whenever they wanted to, you didn't track their time, they might have worked over 40 hours, they might not have accurately even logged the amount of hours they put in a day. The Department of Labor would try to calculate that and assess it all against the employer. Under state law, you would be liable for back wages, benefits that they weren't able to participate in, and back overtime. If you have ERISA plans such as health insurance or retirement plans that they would have been eligible for if they were classified as an employee, but they couldn't participate because they were classified as an independent contractor. It could be very costly in that, for instance, a situation that does happen sometimes is medical insurance. They weren't an employer, they weren't offered medical insurance, they weren't on your plan, they get very sick, they need insurance. It's later determined they were an employee. The employer could get stuck with the medical bills that they incurred that would not have, that they wouldn't have been stuck with if they had been able to participate in your health insurance. With taxes, the IRS and the Michigan unemployment system will hold the employer liable for back taxes the employer would have owed on the employee. So the employer portion, you could be held liable to pay the IRS or the state or the unemployment systems, and they can also hold the employer liable for the employee portion on the taxes if the employee doesn't pay their taxes. So it's a real risk bringing someone in as an independent contractor if they are not clearly an independent contractor. And interestingly, after Claudia and I put this together, a new case came down this week on the issue of employee versus non or independent contractor in the workers' disability arena. In Drob versus J.J. Knapp, the plaintiff worked part-time as a bartender for a business for many years. She had a full-time job somewhere else. She was paid under the table. The owner didn't claim her as an employee for work comp purposes, didn't pay any employment taxes. So they both treated her as an independent contractor. Well, the woman fell and broke her ankle or something while she was working. And when she asked the employer to report it to their insurance company, the employer said, no, you have to bring a work comp claim. So the plaintiff, the employer, I think, never turned it into work comp. The plaintiff ended up suing the owner, claiming she was an independent contractor because the owner never treated her as an employee. And so therefore, she was not prevented from suing the employer. Normally, if you are injured at work, you can only, your only recourse is to go through the work comp system. And she went outside of that, sued the employer. It wasn't a gross negligence situation, which is really the only way around work comp if you're an employee. But she said she didn't have to go through work comp because she was an independent contractor, and the trial court found in her favor. It got to the Court of Appeals, and they affirmed. They both looked at the multi-factor test, determined that she was an independent contractor, and they allowed her to bring a premises liability case against the employer. So again, instead of taking advantage of the protections of the work comp system, that employer kind of shot themselves in the foot, if you will, by forcing the employee to be an independent contractor, and it came back to haunt them in the long run. So just kind of an interesting case right on point. I think the next topic we were going to cover is at will versus, yeah.
Before you move to the next slide, does that also mean that when she sues the bar in court that she can get pain and suffering damages that wouldn't be available under workers' comp?
Right. She can get a lot more damages than would be, she wouldn't be limited to 2/3 of her wages and her medical bills. Yes, you're right. Additional damages
that's a big consequence.
Yeah, definitely. So our next topic is at will versus just cause versus satisfaction. Most of you probably are familiar with what it means to be an at-will employer. Under Michigan law, employees are at will unless the employer creates a different relationship, which we'll talk about. But basically at will means either the employee or the employer can end the employment relationship at any time for any reason or no reason, with or without notice. You just can't fire someone, terminate, end the employment relationship for a discriminatory reason. On the other hand, in a just cause relationship, the employer can only terminate the employee for cause, which is kind of a term of art. It means the employee has done something wrong to warrant termination, basically. There is no legal definition of just cause. Some collective bargaining agreements define it, but it's a very difficult thing to do. It's a factual determination in every case, and it's kind of a moving target. It's hard to put a definition in your handbook. It's even hard to put it in a collective bargaining agreement. And so it's out there and it's open to interpretation. A just cause relationship, meaning that the employer can only terminate if the employee, I'm simplifying it, but has done something wrong. It can be created by contract, where you have an employment agreement with someone and you say that they're going to be employed for a certain period of time unless there is just cause to terminate them. It can also be formed, a just cause relationship can also be formed by statements in a poorly drafted employee handbook, and sometimes even by stray comments by a supervisor or an HR person. And so you have to be very careful. I think employers understand the significance of entering into an employment agreement that contains just cause language. And if you have collective bargaining agreements, they are just cause by just the nature of the relationship. But employers need to be very wary of making statements in their handbook or having supervisors, pat the employees on the back and say, you're just such an asset to the company. We hope you can, we plan to keep you until you retire. Things like that could create a just cause employment relationship. So it's very important for employers to emphasize repeatedly on applications, in their handbook, at trainings, that they intend to have an at-will relationship with their employees, and reiterate that, because the courts will uphold that if the employer can point to the fact that they advised their employees that they were at will. And then the third type of relationship that we don't see very often, but it is out there and certain employers have it, is called a satisfaction relationship. And it's basically an at-will relationship, and it's where the employer agrees that if the employee performs satisfactorily, they will not be terminated. But since it's totally the employer's decision as to what satisfactory performance is, it's basically at will. The main difference is that the employer would likely have to give a reason if you terminate a satisfaction, an employee who had a satisfaction relationship. So at will, you don't have to give a reason. For lots of reasons, that's not our general advice. You usually do want to give a reason, but that's a whole nother topic. But you don't have to with at will. With just cause, you have to. And with satisfaction, it can be, and so with just cause, it has to be a reason that reaches a certain level, like they have to do something bad. With satisfaction, you have to give a reason, but it can be anything that's not discriminatory, because you could just say they didn't, satisfy your expectations. So it's a little twist. I think the places where I've seen it are employers who have been successful in getting unions out of the workplace, and so it's kind of a bone that they throw to their employees that they're not just at will, even though it's pretty much treated like at will, but it doesn't rise to the level of just cause. But if you aren't in that situation, you're probably going to want to be at will. So our default position under Michigan law, all employees are at will unless a different relationship is created by an employer's affirmative actions, such as, giving out employment contracts, collective bargaining agreements, certain handbook policies, or stray statements. And you are safest if you maintain an at-will relationship with your employees. If you do enter into a just cause relationship with them, you can be liable for contract damages. If a court determines that a contract has been created either on purpose or inadvertently, an employer that breaches that just cause contract, which could be oral, could be held liable for damages, including lost wages, both back and future lost wages, and benefits the employee would have received but for the breach. And then I think we're going to move on to Claudia, who's going to tackle the topic of exempt versus non-exempt. Thanks, Claudia.
Thank you, Laura. So this involves both the Fair Labor Standards Act and its Michigan counterpart, which is the improved Workforce Opportunity Act. I don't know if you remember, but a few years ago they came out with the Workforce Opportunity Act, and then in the lame duck session they changed up the law and reduced the minimum wage that was going to come out and called it Improved Workforce Opportunity Act. Generally, you'd have to be a very small employer, maybe just a seasonal employer, to escape the Fair Labor Standards Act. Generally, that the federal law applies. So we're just going to look at that. But non-exempt employees are those who are paid on an hourly basis. They call them non-exempt because they're exempt. They're not exempt from receiving overtime pay. And that means that they have to receive time and a half their regular rate of pay for all hours actually worked over 40 in a work week. Notice I said regular rate of pay. That isn't necessarily their hourly rate. So you have to keep in mind that you have to look at all income that you've provided them that week. Certain income has to be included, and then you calculate their regular rate of pay for that week and paying the time and a half for those hours over 40. Certain employers like hospitals can use the 880 rule, and they pay employees overtime when they work either over 8 hours in a day or 80 hours in a 2-week period, but only certain employers are allowed to take advantage of it. Personally, I think this is seldom a good deal for the employer because it seems like they're always going to work over 8 hours in a day, and they're going to end up getting overtime. Exempt employees, on the other hand, are those who are exempt from overtime, and sometimes the minimum wage rate too. Believe it or not, doctors and lawyers are exempt from the minimum wage rate, and they can be paid on a salary basis or in other ways, which Laura's going to cover in a few minutes. Exempt employees must get annual compensation no less than $35,568 a year for you to classify them as exempt. That comes down to $684 a week. Exempt employees must also satisfy the duties test. The default position on this obviously is the non-exempt hourly employees. Generally, mistakes occur by employers when the worker's job fails to satisfy the duties test. That seems to be where it's most difficult to make the determination as to how to classify them. So all employees can be classified as non-exempt. That's safe. That's your default position. That is the presumption under the law. You can pay your CEO of the company as a non-exempt employee paid on an hourly basis if you want to pay their overtime as well. The consequences for misclassifying employees, there are some that you may not have considered. I mean, obviously, you know that if you misclassified them, then you haven't paid them the overtime that they're entitled to receive. They probably haven't even punched in and out and created time records to help you defend their claims. So the biggest consequence, of course, is the potential for a collective action to be brought against you by all the employees holding that job position that you misclassified. Another consequence is that if you announce the possibility of bonuses at the beginning of the year, for example, I don't know if you know this, but you have to go back and recalculate the overtime pay for employees who are or should have been classified as non-exempt. And you have to recalculate their overtime for all the weeks that the bonus covers, the entire period. So if you give a year-end bonus, you have to spread that bonus out for the entire year and recalculate their regular rate of pay for the time and a half payment. So that's another problem that companies have when they misclassify. They miss the calculation. Maybe you're giving your executives a bonus based on corporate profits or something. As it turns out, if some of them, you're calling them managers, for example, but they really aren't managers, and they should have been classified as hourly, non-exempt, then that means that bonus has to also be recalculated into their new hourly rate and paid. So that's a significant consequence if you've misclassified exempt to non-exempt. Another issue is under ERISA. A lot of companies have different benefits, ERISA benefits for exempt and non-exempt employees. So, for example, exempt employees may have a different type of retirement plan or a different health care plan. And if you failed to properly classify the employee, then that means you excluded them from the correct ERISA plan. And you've probably failed to include the employee in the correct plan. This can result in an ERISA violation, and under ERISA, there can be individual liability in some cases. So after first classifying a worker as an independent contractor or an employee, the next is, are you going to make them at-will, just cause, or satisfaction employees? And here the issue is, will the employee be exempt or non-exempt? Next slide, and I believe this is going to cover salary and other types of compensation plans, and this is back to Laura.
Thanks, Claudia. So next we're going to cover salary versus per service and other compensation plans. So I think everybody is familiar with hourly. You agree to pay persons an hourly rate. As Claudia said, those will be non-exempt employees. You can also pay your people who would otherwise qualify to be exempt as hourly, but then they would be non-exempt. Salary is, I think everyone's familiar with, you basically get the same amount for every week that you work. But under the Fair Labor Standards Act, it's if you have exempt employees that you pay a salary to, it's a term of art. They call it, they have to be paid on a salary basis. So I think I jumped. You can also pay your non-exempt employees a salary based on their hourly rate, but paying them a salary does not make them exempt. They would still be non-exempt. They could be paid a salary, but they also have to be paid overtime if they work more than 40 hours in a week. Under the Fair Labor Standards Act, exempt employees must be paid on a salary basis, which is a little bit different. If they're paid on a salary basis, they are not entitled to overtime. They get a set salary for every week they work, regardless of how many hours they work. There are very few exceptions or allowable deductions from an exempt employee's salary. So a salary basis means the employee regularly receives for each pay period on a weekly or bi-weekly or monthly basis a predetermined amount constituting all or part of the employee's compensation, and that salary amount is not subject to reduction because of variations in the quality or quantity of the work performed. It has to be at least $684 per week, and an exempt employee has to receive their full salary for any week in which the employee performs any work without regard to the number of days or hours worked. So there are certain enumerated reasons, and they're very specific and don't come into play too often, where you can deduct from an exempt person's salary. But in general, you need to know that if you're classifying someone as exempt and not paying them overtime, that they have to be paid on this salary basis. There is an exception if an exempt employee doesn't work at all during a week, then they do not have to be paid their salary with certain exceptions. Again, there's always an exception. Fair Labor Standard Act is just a minefield, and I think all of you know it. But in general, salary is when they get a set amount every week, and salary basis is when you can't deduct from that salary if you want to treat employees as exempt. There's also a provision under the Fair Labor Standards Act, and Claudia referenced that under these exceptions, you're allowed to have per service type arrangements, and this type of payment or compensation applies to exempt employees who qualify for the exemption under either the administrative or professional employee classifications. So in general, we have the white collar exemptions are administrative, professional, executive, computer, and outdoor sales. Executives cannot be paid according to this per service arrangement, but administrative or professional employees can. And what a per service compensation arrangement is that compensation can be paid on a fee basis rather than a salary basis, and the employee will still be considered exempt. An employee is paid on a fee basis if the employee is paid an agreed sum for a single job, regardless of the time required for its completion. Generally, the fee is paid for the kind of job that is unique, rather than a series of jobs that are repeated an indefinite number of times and for which payment on an identical basis is made over and over again. This fee basis can apply to registered nurses who provide home health care services and are paid on a per visit basis only if each visit is unique and the nurse is not simply performing a series of rote jobs over and over. If each visit is not unique, or if the visiting nurses are paid a combination of a fee and an hourly rate, they won't be exempt. Doctors, lawyers, and teachers do not have to be paid on either a salary basis or fee requirement, and they would still be exempt. There's also an exemption for computer-related occupations if they meet the applicable exempt duties test and are paid a specified hourly rate. They can qualify as exempt even though they're not paid on a salary basis. And I have the figure 2763, but I believe it's higher right now. If anyone had a question about that, you could let us know and we could let you know. I think that it changed and I missed it. Sorry. As far as default position, it's always safer, as Claudia said, to classify people as non-exempt and pay them hourly. Because again, if the Department of Labor or the state of Michigan comes in and investigates, they are going to always take the position that the employees are non-exempt and should have been paid overtime, and it will be on you as the employer to prove otherwise. You have to prove the exemption. And so if they can properly be classified as exempt, you're fine. But if there's any question, or if you don't want to deal with it, then it's better to just qualify people, to classify people as non-exempt as your default position, pay them the overtime if in fact they work over 40, and you could save yourself some headaches in the long run. You can always do more than is required. So if you do have, I get this question sometimes, that I'm sure Claudia does too. If you have employees who you treat as exempt, you can pay them overtime if you want to, but you don't have to. So just make sure that the people you're classifying as exempt are qualified based on the duties test, and that you follow all the rules regarding the salary basis when you're compensating them. As far as consequences, if you misclassify, I think Claudia touched on it too, but it doesn't hurt to reiterate. If otherwise exempt employees aren't properly paid on the salary basis, including if you make prohibited deductions from their pay, or dock them for a day's work or a half day's work when they should have been paid, you risk them losing their exempt status, which means they're eligible for overtime, which could be significant depending on the amount of hours a person works. That's one of the problems when a person's been misclassified. Not only are they entitled to back overtime, but they could be entitled to back pay, because many exempt employees work well over 40 hours a week for their salary, which is fine if they're properly classified. But if they're misclassified, all those hours over 40 could be found to be unpaid hours, depending on what the rate of pay was, because you have to pay at least minimum wage. So not only would they get overtime on it, they may be entitled to back pay on that time. If the DOL comes in and investigates and forces a reclassification, they can go back. They regularly go back 2 years, and if they find that the misclassification was willful or intended by the employer, then they can go back 3 years. So the damages can add up fast. So be very careful, not only with classifying your employees, but with how you compensate them based on the classifications. So now Claudia is going to cover bonuses versus commission.
And I'm so glad I get to do this one, because it's one of my pet peeves. Because I got to tell you, the sales representative statute that was passed back in 1992 is just evil for employers. Well, I shouldn't say that. It's a bad deal. So at any rate, back in 1992, the legislature passed this new law that was intended to protect sales representatives. I think they were looking at sales reps in the automotive industry, and they were selling products, and then they would get fired and they wouldn't get their commissions. And so I think that's what this law was designed to help. It doesn't cover salespeople who are selling services, but what you consider to be a service and what you consider to be a product is kind of an odd thing. It's like if you're selling lawn care services, putting down fertilizer, I think that's been viewed as a product, the fertilizer. So just keep that in mind. It was stuck in the Revised Judicature Act of 1961, which again is kind of an odd thing, because that's the law passed in 1961 that covers like statute of limitations, jurisdiction issues for lawsuits, venue, all kinds of weird things. So this is a reason why it's important that you work with an attorney who's familiar with Michigan law, because an out-of-state attorney would never find this law. But talking about commissions and talking about bonuses are covered under the Wages and Fringe Benefits Act. And that's the law that addresses such things as frequency of paychecks, what you do if an employee dies, what happens with fringe benefits like vacation time and so on. So I guess the question is, how does a sales commission and bonus differ? Well, I'm awfully glad you asked. A commission is expressed as a percentage of orders, sales, or profits. So, for example, I will pay you 2% of all gross profits of the products you sell. That's an example of a commission. A bonus under the Wage and Fringe Benefit Act is actually structured a little bit differently. And what you do is you create an incentive plan, and that is not a straight percentage. I had one of the first cases under the sales representative statute back in, it was actually 93. And I argued that this law did not get triggered by the sales commission that had been promised to this employee, because it was set up, for example, in this way, like if you sell up to $100,000 of profits, I'll pay you 1%. But when you hit 200,000, I'll start paying you at 2%. When you hit 300,000, I'll start paying you at 3%. So it's kind of a sliding scale. And I got to tell you, this energizes the salesperson too, because they're motivated by, sales and the numbers and the commissions or bonuses they get, and this really makes them strive to do better. So it's important to set up the different programs. Actually, commissions are also covered under the Wages and Fringe Benefits Act, but it's viewed as a wage, as part of the wages. And there's very little that you can do screwing around with the commissions. So the default would always be create a bonus program. It upsets me like nothing else when my clients set up a commission program and they never ask me for advice on this, because commissions are very dangerous. So under the Wage and Fringe Benefit Act, here's one of the beauties of it. Because this is bonuses, under the default, bonuses are fringe benefits, you can do just about anything you want with them. So for example, you can say to the employee, you can structure the plan any way you want. You can say, for example, as you have to be employed on the date that it's earned, or on the date, and each of these are key. What triggers it being booked? What triggers it being earned? And what triggers the payment of the amount? So there's 3 times in that you look at this. So perhaps booking would be, when you get the signed contract back from the client, and then earned may be when the product has been shipped, and 30 days after that to make sure it hasn't been refunded. And payment could be at the end of the quarter. It will be calculated, and you'll get that payment within 3 weeks or something. Another thing that you need to always put in there, whether it's a commission or whether it's a bonus, you should always consider the procuring cause doctrine. This is such a dangerous deal, because basically what it's saying is, hey, I got that client for you, and I'm going to earn commissions or bonuses for as long as you service that client. So 10 years down the road, they're still selling products to Ford, and they're still wanting their commission or bonus. So regardless of which plan you go for, and of course you should go for the bonus plan, you should probably add a sentence that disavows the procuring cause doctrine, that it doesn't apply. So this is a very easy fix. But the consequences of doing it wrong can be exceptional. Under the sales representative statute, when an employee, and it doesn't even have to be an employee, it could be an independent salesperson that you've hired, the consequences of making a commission contract with them is that at time of termination, you have to pay to them all amounts due within 45 days of their termination, or 45 days after you can determine what the amount of commission is owed. And there's no getting around it. You can't say, for example, you still have to be employed on that day, because that's viewed as waiving the commission and their rights under the Act. And so the consequences of selecting commissions are significant. You can even have a good faith dispute. If you didn't pay it within 45 days, you've got an issue, because not only will you end up owing to the person the amount of the commission, but you also have to pay to them twice the amount as liquidated damages, because everything is found to be, an intentional violation. Plus, you have to pay their attorney's fees. So I recommend that you set it up like a bonus, because under that, about vacation. You don't have to pay vacation out at time of termination. There's no consequences to the employee benefits. They end when the employee leaves, and you can also say, for example, that you will only get up to so much of it paid out at time of termination, and in exchange for a full global release of all claims. So, the consequences of choosing commission over bonus is huge. Avoid commissions at all consequences. And so now we're going to move to Laura with overtime versus comp time off.
Thanks, Claudia. This one probably is pretty familiar to everybody too, so I'm going to try to speed things along a little. See that we're a little short on time. So both the Fair Labor Standards Act and Michigan's minimum wage and overtime laws require employers to pay non-exempt employees overtime for all hours worked over 40 in a work week. A work week is a it's a period of time that is 7 consecutive 24-hour periods. And when you're looking to see whether someone is owed overtime, you cannot average the hours over the pay period. A lot of employers say, well, I have them work 36 hours one week and 42 the next, so it's under 40 when you average it. You're not allowed to do that except, as Claudia said, with hospitals, and there are certain other exceptions for police and fire. But in general, you only look at the 40-hour work week, and that's how you determine if they're eligible for for overtime. If they are, you have to pay any hours worked over 40 at time and a half for each hour. And Claudia talked about this before, but if you have to pay overtime, it's actually based on their regular rate of pay, not their hourly wage. And regular rate of pay can include on-call pay, non-discretionary bonuses. If you pay, say, an attendance bonus, that has to be spread out over the whole pay. However, say it's quarterly, you would have to spread that out and put it into the overtime calculation for each week. Shift differentials are included in regular rate of pay. If some employers may pay traveling expenses to and from work, if you do, that is included in the regular rate of pay. In addition, if an employer, for the employee's convenience, takes out employer designations to charitable contributions, their portion of insurance premiums, retirement contributions, etc., all that, the value of all of those go into the regular rate of pay calculation. So just when you're determining overtime, it's all the remuneration they got that week, not just their hourly rate. So that's just a caution. Regular rate of pay does not include paid time off, such as vacation, sick time. It doesn't include discretionary bonuses, holiday pay, premium pay, callback premium pay, the employer portion of insurance premiums, uniform allowances, or payouts of vacation time. So under the Fair Labor Standards Act, there are pretty much specific lists of what is in the regular rate of pay and what is not, which you can find online. We frequently get questions from employers as to whether they could just give employees who've been working a lot of hours comp time off, compensatory time off, rather than pay them overtime. If you are a public employer, you can do that. If you are a private employer, you can't do it. It's very simple. Don't do it if you are a private employer, at least with respect to your non-exempt employees. Again, you can do anything you want over and above what's required. So if you want to give your exempt employees comp time off, that's fine. And comp time off is in lieu of overtime. It has to be paid at a rate not less than 1.5 hours for each hour of employment for which overtime compensation is required. So if you're a public employer and somebody works 5 hours of overtime in a week and you have a comp time policy, you would give them 7.5 hours of comp time instead of 7.5 hours of their regular rate of pay. The default position is, as we talked about before, the safest position is to classify employees as non-exempt, pay them minimum wage and overtime, at least minimum wage and overtime for all hours worked over 40. Because again, Department of Labor will always start with the premise that employees are non-exempt and it's up to the employer to prove the employee is exempt. An employer who improperly pays comp time in lieu of overtime or makes any wrong decision with respect to compensating employees risks a collective action lawsuit, which Claudia touched upon, but these are really expensive lawsuits to defend against, and they're very lucrative for plaintiffs' attorneys to take. And they're the wage actions under the Fair Labor Standards Act are just ripe for collective actions, because in order to have a collective action classification, you have to have a whole group of similarly situated employees who were similarly treated. And so with respect to misclassification of a department or non-payment of overtime or something, everybody's going to have been treated the same way and have the same issue. And so judges will allow them to all join in one lawsuit. And again, it's expensive for the employer and cheaper for the plaintiffs. A lot of plaintiffs' attorneys won't take just a wage and hour lawsuit because oftentimes the damages are pretty small. Like they just don't add up. But if you get to take a couple hundred employees in one lawsuit, these damages add up pretty quickly, and they're all about that. If you're found by the Department of Labor or a court to have improperly paid employees, the employer will be liable for back amounts going as far back as 3 years. Damages can include back pay, liquidated damages, which is basically double the back pay owed, interest, and attorney fees. So choose your compensation correctly is the warning there. Claudia is going to talk about part-time and full-time.
All right, so this is really a matter of, excuse me, a matter of your policy and your handbook. And I do a lot of handbook reviews, as Laura does and most everybody in our section. And what always cracks me up is the black hole. It's like, this is how I see it defined. Full-time employees are those who are regularly scheduled to work 40 or more hours in a work week. Part-time employees are those who are regularly scheduled to work less than 30 hours a week in a work week. And it's like, okay, so what are those employees who work 30 to 39 hours a week? I mean, the black hole, what are they? So look to see what your handbook says. And my question is always, what's the distinction that you're making, and what are you using it for? I mean, if you're using it just for who gets vacation time and who gets sick time and who gets paid holidays and stuff like that, that's one thing. But there's a bigger scope than this. So, you know, you have to look at what the consequences can be to calling someone part-time and treating them as part-time for all purposes versus full-time. So, for example, the Paid Medical Leave Act, PMLA, they consider people eligible for that if they regularly worked 25 or more hours a week during the last calendar year. So that's 1,300 hours a year in a year. The Family Medical Leave Act qualifies people who have worked 1,250 hours during the rolling 12-month period before them. Another pet peeve, why could not the state legislature have used the same amount that the feds did? 1,250 would make it a lot easier. But be that as it may, look at COVID leave, our new federal leave laws. While it doesn't affect who qualifies for those leaves of absences, it does affect the amount of the payments that they would receive if they're off for those 2 weeks or if they're off for child care. ERISA, definitely eligibility issues there. I mean, under the Affordable Care Act, if they're regularly scheduled to work 30 or more hours a week, and then you have to offer them health insurance. And the same thing holds true for your retirement plans, whatever they are, 401ks, for example. You have eligibility rules, and you can't say that only full-time employees are eligible for the retirement plan. You have to file and then define them as 40 or more hours a week in your handbook. You have to look at the summary plan description and see what it says. And for the most part, I'm seeing that for health care and other health insurances, life insurance, the retirement plan, they're usually all based on the 30 hours or more a week. So sure, you can define them as part-time versus full-time in your employee handbook, but the consequences of having not looked at your summary plan description or just thinking that all full-time employees can qualify for different kinds of leaves or your ERISA plans would be a problem. So make sure you delve down into it and come up with a better description in your employee handbook. Laura, I think you have the last slide.
Thanks. And we just wanted to touch on PTO versus sick and vacation time. A lot of employers have gone to PTO or paid time off banks, which basically lumps all the paid time off in one pot and lets the employee determine how they want to use it. The opposite is having a vacation bank and a sick leave bank, and the employee has to use vacation time if they want to take vacation or personal time, and they can only use their sick leave if they're sick. So with PTO, the employee has more ability to direct how they want to use their time. Either one is okay depending on what the employer wants to do. But with the PTO bank in Michigan, you have to be very careful how you draft your policy. If you have 50 or more employees, you're subject to the Michigan Paid Medical Leave Act, which took effect a couple of years ago. And so your PTO policy could include paid medical leave time, but you are going to probably have to draft, you're probably going to have to redraft it if you haven't already done so, if you want to include that time there. Because you can't have just a general notice policy that people have to give you a week's notice if they want to use it this time, because they can't give that notice if they wake up sick. And there are accrual requirements. There are purposes for which it has to be available, and your PTO policy should reflect all that information if you are lumping your paid medical leave time into your PTO policy. In the alternative, you can have vacation time and sick time, and it gives the employer a little more control over how the time is used. If employees are going to be awarded vacation time, you can set all the rules for how it can be used, when it can be used, and that it can or can't carry over, that they have to give certain notices, and then you would have a separate sick policy that would meet the requirements of the Paid Medical Leave Act, and it could have the effect of limiting the amount of time taken, because with PTO, an employee can exhaust their whole bank on vacation time if they want to. You can't really restrict it. You have to make sure they have it. If you're subject to the Paid Medical Leave Act, you have to make sure they have at least 40 hours available in PTO, and that it's available for the reasons allowed under the Paid Medical Leave Act, but you don't restrict how the time can actually be used. So they can use time that you basically intend for them to use as sick leave as vacation time. And then when they do become sick, if they do, you're likely going to end up just giving them unpaid time off, because most employers, just end up doing it because you don't want them in the workplace if they're sick. So it's a little bit more of a risk for having employees use additional time that they might not have coming to them, because if they don't allocate it, or save time for sick issues, then likely you're just going to end up giving them additional time. If they have vacation time and they burn it all, and they have sick leave that they don't burn, you can control within the parameters of the Paid Medical Leave Act, if you're subject to it, what happens to that time. Some employers allow a bank to build to a certain extent and have carryover, others don't. Some pay it out at the end of the year, and others just employees lose it and get their sick bank for the next year. So with sick and vacation time, you might not have employees using all the time available to them. Generally with PTO, I think most employers find that the employees burn all the time that's out there available to them. So I did just a quick bullet point to highlight the differences. And PTO, you have one category, employee chooses how to use it. All the time is subject to the same rules, with the exception of time subject to Paid Medical Leave Act. And another thing I didn't touch on is the employer would be required to track the use of time to make sure the employee gets their 40 hours of paid medical leave under PTO. If you had a sick leave bank and they got their 40 hours, you don't have to track it. If they're using it, it's going to be for a purpose that's allowed under the Paid Medical Leave Act. And again, under PTO, employees could exhaust all their time as vacation and maybe end up with additional unpaid time off. The benefits to sick vacation banks are you can set separate rules for use. You ensure your employees have time available for illness and paid medical leave reasons. If they don't use it, you can determine what happens to it going forward. And you, again, may end up paying less time off, since they can only use it for illness, not additional vacation time. So I think that, unless Claudia has something to add, that covers the topics we had for today. And we thank you for coming.
Let me jump back
Are
in
there any questions?
Let me jump back in real quick and see. Right now, I see one question. I do have a couple of responses out to folks that asked some items early on, but I wasn't exactly sure what they were asking about. So I'm looking for clarification there. So take a look at the questions queue for those folks that asked me those two questions. There is one question that is about outside sales employees, and this one is, we're short-staffed, so we brought on an outside sales employee inside to work the counter, which is an hourly paid position. Should we now reclassify him to non-exempt for this other role? He's working about 9 to 10 hours per day.
I would. Assuming that this is, he's now transferred into a new counter in-house position, then he's got to be paid like the other in-house salespeople. You can't, he's no longer an outside salesperson. If you transfer him back out into the field at a later point, then you can reclassify him as a salaried employee.
Yeah, he has to be non-exempt if he's inside sales.
Great. I don't show any other questions, so if anybody has anything, please type it in right now. If not, we'll move along. Actually, what I can do is I'll monitor the questions queue. Go ahead and enter anything you have. I'll get through the rest of my closeout, and then we can sign off for the day. I know we're getting close to our time here, so I do want to keep it moving. Just as we always do for those that have been on our webinars in the past, we do send out a post-webinar survey right after the conclusion of today's event. So please fill that out. It only takes a minute or two, and we really appreciate especially the topics you suggest for future webinars. So please give us that feedback as well. And we take all of that to heart and share it with our entire practice group. So please do that. As I had mentioned, and I promised to come back to this, today's program is approved for 1.25 hours, of HRCI and SHRM accreditation. Due to the Thanksgiving holiday, we're a little short-staffed, so if you can all just give us until early next week, we will email those certificates to you. And again, if anybody receives a certificate but doesn't need it, you can just disregard it. There's no follow-up needed on your end, but we're probably going to get those out Monday or Tuesday at the very latest. So please look for those in your email. Again, I had mentioned that today's program is recorded. The recording is going to be posted hopefully later today. You can direct anybody that has missed this program to the link, or if you'd like to revisit the recording or any portion of it, you can do that there on our event page. Choices have consequences. The links will be at the bottom and top of the page, actually. And I also always want to refer everybody to our Sophisticated Employer blog. Claudia, Laura, and others in our group write for the blog, and periodically there are updates that get pushed out. So if you add your email on the left-hand side, you see a little email area. You'll get notifications when new content is added to our blog. So we hope you join us there as well. And on behalf of Laura and Claudia and myself and all the members of our Employment Law Practice Group, I want to wish everybody a happy Thanksgiving. I don't really see any other questions in our queue, so we're going to end it at that point. If anything pops in here late, we'll follow up individually. So please stay safe out there. Have a great Thanksgiving, and we'll see you at our next program. Thanks for attending, and take care.